All right, the record should reflect now that the defendant is present with counsel. You may be seated if you wish. And would counsel state their appearances for the record?
Good morning. Shapiro and Gerald Uelmen for Mr. Simpson was not present.
And good morning, Your Honor. William Hodgman for the people.
Marcia Clark for the people. Good morning, Your Honor.
Good morning. All right, there are a number of matters on calendar today. I think one matter that can be resolved in fairly short order, and that relates to the hair sample, that the court did grant an order for a hair sample. The defense submitted an order to the court requesting to limit that hair sample to one hair. I did have my clerk contact the district attorney's office to determine whether they were in agreement with that order, and the indication was that they were not, and therefore I've done nothing with regard to that order to this point. Ms. Clark, how much hair do the people need?
Well, Your Honor, hair samples, as I'm sure the defense must be aware, in order to be effectively compared with an evidence sample recovered from a crime scene, has to be taken from each area of the suspect's head. And that means that a minimum of 5 to 10 hairs from each area, which usually amounts to about 100 hairs. Any scientist, no matter how inexperienced, is aware of that fact. You cannot do an effective comparison between a known standard and an evidence standard without that size of sample.
So you're asking for 100 hairs?
We're asking for as many hairs as the criminalist or expert determines is necessary to effectively compare the standard hairs from the head of the defendant with the hairs found at the crime scene. And I've never seen a court attempt to restrict that, because that is obviously a matter that a criminalist would have to determine based on what he can recover.
Mr. Shapiro?
Your Honor, according to Dr. Henry Lee, our chief criminalist, who is the head of the Department of Criminology in Connecticut, he tells us 1 to 3 hairs are sufficient. I think perhaps this may be an appropriate matter for the court to have a hearing on. I think 100 hairs is unduly invasive. Makes the inventorying of the hairs a very, very difficult task, and certainly allows for the possibility of the commingling of samples, which could contaminate any test. So we would ask for a hearing on this. I've been practicing for a long time. I've never, ever heard of such a request.
Right. This is what I'm prepared to do at this point in time, and that is to order no more than 10 hairs at this point. If the prosecution at some point feels that they are in need of more hairs than the 10 that I'm going to allow at this point, then we will have that hearing with experts if necessary. This is not a matter that the court has independent expert knowledge concerning. So that's going to be the order at this point in time, subject to a further hearing with evidence, if necessary, from both sides for anything beyond 10 hairs.
Your Honor, I don't think that counsel has conferred with Mr. Lee concerning the nature of the test involved. If Mr. Lee if Mr. Lee has informed counsel that only 1 to 3 hairs are needed for microscopic comparison, then he has misinformed counsel, and I can state that categorically. I'm very surprised to hear Mr. Shapiro has never heard of the number of hairs I have just indicated to the court being required before, because that is a standard thing. When a microscopic analysis is endeavored, it is required that you have standards from every area of the head, 10 hairs per area. That's a standard. I'm not talking about anything unusual here.
Right,
and what Mr. Lee is talking about, Your Honor, is PCR work. That's a whole different thing. We're not talking about comparison only for PCR. We're talking about comparison for microscopic as well.
All right. This is what I indicated I was willing to do at this point. You're of the opinion, and it may indeed be the correct conclusion, that you're going to need more than that. And the bottom line is that if, in fact, you do need more than that, you are going to have to produce an expert to justify that to the court. And if indeed that justification is made, I will sign an appropriate order.
Thank you, Your Honor. We will present that testimony today.
Today?
Yes.
Very well.
Thank you very much.
Okay. Now, yes.
On the matter before you do that issue, we do not have an indication as to how many follicles or shafts were found that the people are going to use for a point of comparison. And we asked the court to consider it for you so we would have knowledge of that.
Yes. Ms. Clark, do you know the answer to that question at this point?
I was told just this morning, and I not recall. I'm not going to make a representation. We have an expert here who can tell the court precisely how many follicles and how many shafts there are.
All right.
I'd rather let them say.
Now, you indicate you do have an expert here. Do you want to proceed on this issue of the number of hairs right now, or would you prefer to do that sometime later? What is your preference?
Well, Your Honor, as I understand it, the court had required us to proceed this morning on the issue of the blood split that was requested. So the expert who is going to testify to that matter can also address the matter of the hairs, because she's the director of the crime lab for the Los Angeles Police Department. So we can do it all at once.
All right, that'd be fine. Mr. Shapiro, I assume that you're prepared on the hair issue?
Yes, I am.
Thank you. All right. Then let's also, then in conjunction with the determination of the number of hairs, there remains the determination of the sufficiency of certain blood samples for defense splits. Now, I also should mention that the court is in receipt of the defense motion that was filed to quash and traverse and to suppress certain evidence, and attached as an exhibit to the defense motion was a property report listing certain items of evidence, I think 1 through 34 are denoted there. Is it correct that all of the scientific evidence about which that we're speaking about splitting is included in those items 1 through 34?
I don't believe so, Your Honor. I believe the scientific evidence related to items recovered at the scene of the homicide, 875 India. The motion only goes to the evidence that was obtained at the home of Mr. Simpson.
All right. Does anyone have something to provide to the court with a listing of what specific items we're dealing with if there's going to be different testimony concerning a particular item that was received in evidence, and the court would ultimately be making orders perhaps differing or designating certain samples that would be split and certain samples that would not be split? It would certainly be helpful to the court to have some sort of a number, and the way it's denoted in the property report would make sense, since that's the way all of you will be dealing with the evidence and the criminalists as well. Is there a copy of a property report that could be made available just for the court's use in keeping track of the items of evidence, scientific evidence that we're dealing with, that either of you might have?
And I do that.
Okay. If somebody could hand that to my clerk, it would greatly assist me during this motion. All right, then I guess then we'll just commence with the testimony with regard to the splitting of the evidence at this point in time. Ms. Clark.
Thank you, Your Honor. The people will call Michele Kestler.
Please face the clerk and raise your right hand.
Do solemnly swear that the testimony you're about to give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State and spell your name for the record.
Michele Kestler, Michele Kestler.
Thank you very much. You may inquire.
Good morning, Ms. Kestler.
Morning.
Please tell us what you do for a living.
I'm employed by the City of Los Angeles Police Department, and I am the Assistant Laboratory Director for the Criminalistics Laboratory.
Tell us what that means. What are your duties?
My duties include the managing and overseeing of several areas there, including the serology DNA lab, the trace unit, and many of the other units there.
And what does that mean? What exactly do you mean by that?
Well, and managing it also means evaluating and implementing programs such as serology and DNA, and including evaluating crime scenes and managing task forces or large cases and the employees that are doing the work.
So you direct the criminalists in what to do, basically.
And that's correct.
Were you once a criminalist yourself?
Yes, I was.
Tell us what a criminalist is.
A criminalist is one who collects, preserves, and analyzes all types of physical evidence and testifies in court.
Now, does that mean it's somebody that goes out to a crime scene to collect evidence from the scene
Yes,
of a scientific or evidentiary nature?
that's correct.
Have you also performed trace evidence analysis or blood analysis?
Blood years ago and trace years ago also, yes.
What kind of training did you receive in order to get the current position?
The training in the current position is basically a management position, so I have taken several management classes, but the criminalist position, my training and background includes a master's degree in criminalistics from Cal State University, and then on-the-job training, including courses at the FBI laboratory and California Criminalistics Institute and various other private classes.
And how many years of training is that?
Overall,
Overall.
Master's degree is 2 years beyond your bachelor's. I have probably about a total of 4 years, 6 years invested there, and training in specialty classes probably about another 2 years full-time training if you were to separate it out compared to on-the-job work.
Now, you have your master's in what?
Criminalistics.
And criminalistics, the subject is defined as?
Again, criminalistics is forensic science or all areas of evaluating forensic evidence.
Now, when you say evaluating forensic evidence, Ms. Kestler, what does that mean in terms of your knowledgeability about which tests are available and appropriate to be performed on various types of evidence?
One of the things that a forensic expert must look at in any type of physical evidence, the first thing you do is you look at the evidence, you find out, evaluate what you have, what it is, and then you proceed from there, and the type of testing you would like to do is going to be the most informative and the most conclusive. And you have to evaluate each piece of evidence for that purpose.
And are you qualified to do that?
I believe I am, yes.
Does your training, in fact, qualify you to do that?
Yes, it does.
Now, are you also trained and experienced in determining how much volume of sample is needed for each test that you determine is appropriate to be performed on each item of evidence?
Yes.
Now, in this particular case, was it requested of you to determine whether certain items of evidence that were blood stains recovered from both the crime scene and the residence of the defendant, as well as blood recovered from certain items found at the crime scene and the defendant's residence, were sufficient in quality and quantity for subjecting to certain scientific tests?
Yes, we were asked to determine whether the evidence, our best estimate as to whether the evidence was appropriate for that.
And did you review also the number of tests, a variety of tests or range of tests that could be performed on each item of evidence in order to gain the maximum possible confidence in the results?
Yes, we reviewed the samples and made our best estimate as to what could be done. Of course, there's never any guarantee until the tests are actually done, or you do actually start working with the evidence to determine whether that you're accurate in your estimate.
Now, did you in fact then review much of the evidence that has been recovered in this case?
Yes, most of it.
Tell us, first of all, for purposes of clarity, which items were you unable to examine for the purpose of determining whether a blood split could be given to the defense?
Okay, I'd like to refer to my notes.
Please.
Thank you. Okay, the items that were unavailable to us were items number 61 through 71.
Do you have any knowledge, ma'am, of which items those are?
I have some references to what they are. I don't have any absolute knowledge as to what they are or where they came from. I know what they're listed as.
What are they listed as?
Okay, item number 61, I believe, is a handgun.
A handgun?
A handgun, yes.
Let me just ask you this. Items 61 through 71.
Mm-hmm.
Is it your belief, based on the information you have at hand, that none of those items contains blood evidence?
I'm not sure, because some of those items were recovered by detectives, I believe, and there's indicated, I know, on there some sheets and pillowcases and a towel with a broken glass, so I have no idea at this time.
Is it your information that some of those items listed in 61 through 71 came from Chicago?
That's what I presume, based on what they are. Assuming the detectives collected them, because most everything else that is available to us was collected and booked by our criminalists.
As a matter of protocol, let me ask you something for purposes of clarity, Ms. Kestler. Where can evidence be booked? Are there two places where they can go?
Well, there's many areas. The Los Angeles Police Department has several property rooms, including one that is adjacent to the crime laboratory and one that is in Parker Center, as well as one in many of the area stations. And evidence can be booked at any one of those locations.
Now, the items that you have in fact evaluated for the purpose of this hearing, where were they?
They're all booked at Piper Technical Center.
Which is adjacent to your laboratory?
That's correct.
The items that you were not able to examine, where are they?
They are booked and sealed in a vault at Parker Center.
So items 61 through 71 you were not able to look at.
And also items 88 through 90.
What about items 73 through 81?
73 through 81, we have those items, but we just received those late Friday and have not been able to evaluate them. That is the coroner's evidence. Some we evaluated, the clothing we could not at this time.
The coroner would not release them to you until last Friday?
That's correct.
Was that, if you know, in order to accommodate the defense in examining the evidence first?
That's what we were told, yes.
And items 88 through 90?
Those are booked at Parker Center. And I believe those are from Chicago based on the property report.
So those were not looked at?
No.
Items 91 through 93?
Those were just recovered in conjunction with search warrant that was served on 6/28, and they were booked late yesterday, so we have not had a chance to review those items.
91 to 93, weren't those recovered?
Oh, I'm sorry, 91 through 93 were recovered from a Bronco, but they were also just recovered yesterday. Sorry.
In other words, was other testing being performed on the Bronco?
As
Prior to
far as
that?
I know, it was, and then there was some indication that there was possibly another search for evidence that they didn't want to make in the beginning, and so they went back the second time to look at the vehicle.
But the vehicle remained in police custody?
As far as I know, yes.
Your Honor, may I suggest to the court that leading questions not be asked of this witness unless absolutely necessary?
Your Honor, this is an expert witness who has the reports in front of her.
Expert testimony is not subject to the leading question objection. However, at this point in time, I don't believe she's actually giving you expert opinion. She's rather giving information concerning specific items of a background nature. The objection at this time is sustained. I'm going to ask you, please, with regard to her expert testimony, obviously she can, you can ask leading questions, but on these foundational matters, I prefer if you could refrain from asking leading questions.
Items 94 through 109. Have you looked at those items yet?
No, those were recovered pursuant to a search warrant on 6/28 and booked yesterday at Piper Technical Center, but we've not had a chance to review them for physical evidence.
And items 110 through 113?
Those are items that were booked yesterday also at Piper Technical Center, and those are items that were recovered from other items already booked. And they are trace evidence items.
Are those hairs that were recovered from something else?
They're evidence, including hairs and fibers, recovered from property items, and I can tell you what those are one at a time. For example, item 110 was recovered from item 9. Item 111 was recovered from item number 27.
Wait, item 110
was recovered from item number 9.
What's item number 9?
Again, I'll refer to my notes. I believe it's a glove.
And item 110, what kind of evidence is that?
Yes, item number 9 is a leather right-hand glove.
We have not received a list of inventory items beginning at 91 for which testimony is being offered this morning.
All right, the document that was provided to me, does the defense have that summary as well?
I intended to give the copy that the court has to the defense. If the court can allow us, we have another copy.
Please.
This information is contained in other discovery, but the list that is compiled was just compiled by this witness for her testimony. The information is all in possession of the defense, Your Honor.
Your Honor, that simply is not true. We don't have any information about what was recovered yesterday.
No, this is not pertaining to items that were recovered yesterday. The witness is testifying to items that were recovered some time ago from other evidence. This witness is describing right now trace evidence that was recovered from items that were seized from the crime scene. And the defense is in full possession of that information.
Your Honor, my recollection of the testimony of this witness is items 94 through 109 refer to items seized yesterday from a search warrant. And we have not received any of this information. We asked for it yesterday.
Your Honor, the people didn't have the information either, and none of the items seized yesterday will be the subject of any testimony in this hearing because no one's had a chance to look at it yet. It was so recently seized. And the property reports are presently being compiled. All this witness did was write down the numbers. There's been no attempt, no time to look at those items for any purpose whatsoever. The property report that will be put together with the return to search warrant will be given to counsel as soon as the people get it. At this time, I just asked the witness to jot down the item numbers so that it could be indicated to counsel what has and has not been looked at for future purposes.
All right, so for purposes of the hearing today, no determination whatsoever as to sufficiency of samples regarding items that were recovered in the execution of the search warrant a couple of days ago is being offered, correct?
None.
Okay.
Your Honor, in that regard, my understanding is that as soon as the search warrant is executed, a return to the search warrant must be filed. And as soon as that is done, we would like to have the court order immediately to have those items listed and made available to us.
Your Honor, as counsel should be aware, the police have 10 days to prepare a return to search warrant, at which time the property report listing what has been seized is attached to that return, and the law will be complied with as it has been throughout this case.
Yes, they do have 10 days to file their return, and of course the continuing discovery that is occurring in this matter does require that those matters, of course, be turned over to the defense. And in the event that you do have that completed before the 10 days, I would ask you to turn that over to the defense as quickly as possible.
Certainly, Your Honor.
All right.
So with respect to item number 110 is your number for what?
Item number 110 is just a number given to trace evidence recovered from item number 9.
And
that was a glove. And our policy is that whenever we recover trace evidence, that rather than just putting it in a bundle with the original item, we book it as a separate item number. Now, that evidence was all viewed by the defense in my
trace evidence you're talking about as number 110, which was viewed by the defense last week, was what?
Hairs and fibers.
Recovered from a glove?
Recovered from item number 9, the glove, yes.
And number 111?
Was hairs and fibers recovered, trace evidence again, recovered from item number 27.
Which was what?
Item number 27, I believe, is a cap. I have to keep shifting back and forth. Yes, it's a cap that was recovered from the driver's floor of the Bronco.
And again, that item was viewed by the defense last week as well?
Yes.
And item number 112?
Is trace evidence recovered from item number 37, that is a left-handed leather glove.
And what is the trace evidence recovered from that left-handed leather glove?
Yes.
What is the trace evidence?
It's hairs and fibers in this case.
Also examined by the defense last week?
Yes.
Item number 113?
Was hairs recovered from item number 38, which is a blue knit cap.
Did you say that was hairs recovered from a
Yes,
blue knit cap?
a blue knit cap and some fibers, yes, I'm sorry.
And that was also viewed by the defense last week?
Yes.
So, now with respect to those hair items, I'm going to come back to those later. Let's go back now and address the blood splits that have been requested. Now, based on your training and your qualifications, are you qualified to indicate to this court what volume of sample is needed for each test?
Basically, yes, an overall evaluation.
Now, with respect to items 1 through 60, and items 82 through 87, did you make a determination as to whether a blood split for the defense on any of those items would be possible after the testing of those items on all standards available would be possible?
Yes, we made an estimated evaluation of these samples and found that a few of them appear to be sufficient for a split after the whole battery of tests is completed. There's no guarantee until we complete those tests, however. Other than on the samples taken from the victims and the defendant, there's plenty of sample for a split.
When you say samples taken from the victims and the defendant, you mean?
Those are the standards. The reference samples, the whole blood taken from Mr. Simpson and the whole blood swatches, frozen swatches taken at the time of autopsy from the coroner victims.
Now, can you tell us, identifying by item number, which ones you determined may, after we've completed our testing on them, may permit for a split?
Certainly. Item number 3, which is a cigarette butt, recovered from the street, would be tested, and there should be plenty for a split after we're done. Item number 7 is several swatches containing red stains recovered from a driveway, and it is possible, looks fairly good, that could have enough left for a split after the testing is done. Item number 12 also has several swatches of different sizes, and they are fairly dark red. And again, those appear to be a good possibility for a split after our testing is all done.
Item number 17?
Item number 17, as stated before, is a reference sample from Mr. Simpson, and that there'll be plenty of that available for a split. Item number 42. There is, again, several swatches, fairly medium to dark red in color, and there should be enough for a split at the end of the testing. Item number 44, that's possible. Those appear to be very much weaker, but there are several swatches, and so there's a good possibility of a split on that item also. Number 47, there's plenty there. We pretty much have no question there'll be enough for a split when we're done. Item number 49, I'm sorry.
Can you say for certain that a blood split could be provided before the testing has been completed?
No, not actually. There could be something, this is our best estimate again, there could be something go wrong. There may be not as much white blood cells there as we need, and so we could be wrong. Again, it's a best guess. Without actually starting to extract the evidence and prepare preliminary gels on it, we can't tell for sure. Item number 49. There should be, again, appears to be plenty available for a split when we're done with our testing. Item number 50 is a little weaker, but has a good possibility for a split after we're done. Item number 57, it appears to be possible for a split after we're done testing. Again, as indicated earlier, items number 72 and 82, blood swatches from the victims, will both have plenty of material available for a split after we're done.
Blood samples taken from the victims.
Reference samples, yes. They're listed as coroner's samples. And those are the only items at this time that we feel fairly confident that when we're done, there will be a sufficient sample for a split.
Now, before all of the testing proposed to be done on all of the items has been completed, is there any way to know with certainty whether any of these items can be turned over, can be split and given to the defense for independent testing?
Not without doing the analysis, except possibly on the reference samples. But without doing the analysis, we don't know how much we would need, and therefore could not even begin to estimate how much they would need to have either.
In other words, leaving aside the issue of the reference sample, which I understand the blood samples we're going to have plenty of, with respect to the evidence samples, is there any way to know whether at this time, before the testing has been conducted, there will be sufficient material left to provide a blood split to the defense?
No, cannot give you a definite answer. Yes, that there will be.
Cannot be done.
Cannot.
But at this time, for sure, you can rule out certain items that you know would be incapable of providing a split.
Yes, there are many very, very small samples here that may only lend themselves to one type of test at best.
So the items that you've listed for us today, then, are possibles, but you will not know until the testing has been completed.
That's correct.
Now, with respect to hair evidence, did I inform you yesterday that the defense was making a request to limit the samples of hair taken from the defendant to one hair?
Yes, you did.
And what was your response?
Well, I was shocked at best. First of all, I said, "You got to be kidding," I think was my response.
And why was that?
Because it's impossible from one hair, to make any kind of determination microscopically for a reference standard from one hair to determine whether that's similar to other hairs.
What is the standard number of hairs required, or the method of retrieving sample hairs from a defendant in order to perform a comparison of those hairs to hairs recovered from a crime scene or item of evidence?
The method of retrieval is such that you take samples from all parts of the head, the front, both sides, the crown, and the back. And it's by pulling and combing, because you do absolutely need some of the roots, if at all possible. The second thing is that the recommendation in several articles, including that made by the FBI, is 30 to 100 hairs. And then you take a random sample of that 30 to 100. So they are suggesting that 20 reference hairs from each of the 5 areas, roughly making the 100.
Then let me ask you this. How do you make sure that you don't mix hairs taken from different parts of the head?
That's not important. You can mix them once they're taken from different parts of the head. It's just that the hair differs on different parts of the head, and you want to get an overall random sample, and then you take those and you get a overall picture of what the hair looks like, and then you compare it to evidence hairs taken, because you have no idea where those evidence hairs came from.
Right. When you recover hairs from a crime scene or an item of evidence left at a crime scene, you don't know what part of the head that hair came from.
No, you do not.
And with respect to, as a matter of public habit and custom, are the hairs recovered from the head of a defendant segregated by the area from which they were recovered for reference purposes?
We segregate them sometimes when they're taken. It's not an absolute necessity. It's kind of an individual choice on the examiner.
With respect to comparison and analysis of hairs using the test known as PCR, and that's for DNA, is that correct?
That's correct.
How many hairs would be required to be recovered from the defendant for the purposes of comparing his hair to evidence that was recovered from the crime scene?
Well, for PCR, we usually use the reference blood sample versus the crime scene hair. And as far as hair, it is possible to do PCR on one hair root. That's the minimum amount you must have, but there's no guarantee. There's some ratios, and I don't know the percentage offhand as to how many times that has to be done or how many times they've been successful with one hair. It all depends on how good the root is, the age of the sample, etc.
Then for the purpose of performing comparison, even using the DNA test known as PCR, would you say that it was an accepted scientific practice or procedure to use only one head hair if you were going to compare it that way, taken from the defendant to evidence hair recovered from a crime scene? Would that be an appropriate method to use?
No, I wouldn't compare hair to hair. For PCR, again, I use a reference whole blood, preferably.
But if you did, would you say it was an accepted scientific practice to use only one hair from the defendant for that purpose?
Well,
She's answered that question 3 times. She said, for DNA, we do not need any hair to compare blood to hair.
You know, Your Honor, she hasn't answered my question, and this goes to counsel's representation concerning the fact that he claims his expert said we only need 1 to 3 hairs. And that's why I'm inquiring as to this particular topic.
Do you understand the question?
well, let me see if I can I try to attempt to?
Well, I can reframe it, actually. Let me.
Okay.
Can you tell us whether it would be proper scientific procedure to perform a hair comparison using only one head hair from the defendant to compare to crime scene hairs for any test?
No.
Have you ever heard of any criminalist who would advocate comparison of crime scene hairs to only one hair taken from the head of a defendant?
No.
All right, Mr. Shapiro, will you be conducting the cross-examination of this witness? All right, and I did, at the outset, forget to ask the attorneys if you would use the podium. There are no microphones at counsel table. There is, however, a microphone at the podium, and that way everyone will be able to hear the questions.
Your Honor, may I refer court and counsel to page 14 of our discovery motion, item 29B, which basically asks for a curriculum vitae of all expert witnesses. We have not received that yet.
Do you have a copy of your resume?
No.
Would it be possible to have some, do you have that prepared at your office?
I believe it's in the computer, yes.
Would somebody be able to fax it over here to the building so that can be provided to Mr. Shapiro?
No, because they can't get to it. I'd have to do it when I get back.
Mr. Shapiro, do you need that before you're prepared to begin the cross-examination?
Well, Your Honor, it would save a lot of time rather than going through all of her credentials. And we'd like to examine that. We may be able to stipulate she's an expert, or we may want to contest that.
All right. There's no one else that has access to your computer that can generate that?
I'll call and try. I don't know who's there right now.
All right. Why don't we see if we can facilitate that in the quickest way possible? Are there any questions that you have related not to her expert opinion, that just to the foundational matters concerning certain item numbers, or would it be better just to wait until we can get to her background?
I think the background would be important to have first.
All right.
Thank you.
Okay. Then we will break at this point in time, and if you could get that as quickly as possible, I would appreciate it.
Your Honor, may counsel approach the court for purposes of scheduling only?
Yes. Do you want this on the record?
It can be on the record or off the record, just a personal
All right.
reference to the
Then
court.
I'll see counsel in chambers with the reporter.
Yes, I mean, all matters do have to be on the record. Yes.